Welcome to Chapter 4 of the Contract Law. I am Thanh Huyền from the Faculty of Commercial Law. I'm so pleased to be here to discuss with you certain legal issues on performance of the contract. This week, we are looking at performance of the contract. This means that now we know how to create and enter a contract. We also want to know what constitutes performance of that contract, what are the terms of the contract and their requirements, as well as whether such terms have been complied with. In this chapter, we will examine the performance of the contract under the U.S. law and the Vietnamese law. It should be noted that most contracts come to an end as a result of the party performing their contractual obligation. If a contractual duty has not been discharged or executed, the contracting party owes an absolute duty to perform the duty. There are three main types of performance of a contract. First one, complete performance. Second, substantial performance. And inferior performance. We will take some time to point something out here. As referred, complete performance refers to a situation in which a party to a contract renders performance exactly as required by the contract. Complete performance discharges the party's obligation under the contract, whereas substantial performance occurs when a party to a contract renders performance that deviates slightly from the complete performance. With respect to inferior performance, a party fails to perform its read or implied contractual obligation and impairs or destroys the essence of the contract. As mentioned above, the complete performance or strict performance discharge the party obligations under the contract. A fully performed contract is called an executed contract. It should be noted that tender of performance also discharges a party's contractual obligation. Tender is an unconditional and absolute offer by a contracting party to perform his or her obligation under the contract. Now, we may take the case as an example. A, who owns a women's retail store, contract to purchase high-fashion blue jeans from a manufacturer for $75,000. At the time of performance, A tenders the exact money as required, $75,000. A has performed her obligation under the contract once she tendered the $75,000 to the manufacturer. Then the manufacturer fails to deliver the blue jeans. There is no completed contract here, and A can sue the manufacturer for breach of the contract. As noted, complete performance occurs when the party must have performed their obligation strictly and completely. In other words, the party must have complied exactly with the contract. To determine whether exact performance had occurred, the terms of the contract will be interpreted. Then, the parties' conduct shall be compared with this term. If they are the same, it should be found that the performance has occurred and the contractual relationship has come to its intended end. However, parties can expressly or impliedly modify that general rule. It means that they may agree that exact compliance with their contractual obligation is not actually required for the contract to come to an end. As previously stated, it states that performance must be exact and complete to satisfy the contract. But at this point, it should be considered that when we say exact and complete, what if the contract is entire, but 90% of it has been performed? Does it mean that the party is entitled to nothing, even though they have performed the majority of their obligations? Doesn't this seem a bit unfair? So, it's reasonable to explain what the doctrine of substantial performance is and how it works. The general rules is that a contract must be completely and exactly performed, and therefore the party shall be entitled to payment for their work. But according to this doctrine, if a party has not fully but had substantially performed their obligation under the contract, then pursuant to the so-called doctrine of substantial performance, they may still be able to recover the contract price. However, logically and somewhat fairly, the party who has substantially performed their contractual obligation cannot actually receive the full contract price. The other party will also have the right to a payment as damages, as compensation, because the first party failed to perform their contractual obligation completely and exactly. So that's it. The substantially performing party will receive the contract price minus the amount to ratify their non-performance. In short, substantial performance occurs when there has been a minor breach of contract. In other words, it occurs when a party to a contract renders performance that deviates slightly from the complete performance. The non-breaching party may try to convince the breaching party to improve his or her performance to complete performance. If the breaching party does not correct the breach, the non-breaching party can sue to recover damages by deducting the cost to repair the defect from the contract price and remitting the balance to the breaching party, or suing the breaching party to recover the cost to repair the defect if the breaching party has already been paid. Now we can take the case as an example. B contract with C, a construction company, to have C construct an office building for $100 million. The architectural plans call for the installation of 3 blind windows in the building. C constructs the building exactly to plan, except that it only installed 2 blind windows. There has been substantial performance. It would cost $5 million to install the correct window. If C agrees to display the windows and the show, its performance is elevated to complete performance, and B must pay the entire contract price. However, if B has to hire someone else to replace the window, he may deduct this cost of repair of $5 million from the contract price of $100 million and remit the difference of $95 million to C. The important thing is that how can you know when some performance is enough performance? As usual, it's a case-by-case basis and will depend on the terms of the contract and the subject matter of the contract. In order to determine whether a contract has been substantially performed, it's necessary to balance the extent of the party's correct performance against the nature and extent of the defect in their performance, and also whether the contract expressly or implicitly required the entire performance. Now, we may look at in more detail in a moment about that. Let's examine the case Jacob and Young and Kent, published by the Court of Appeals of New York in 1921. Here is the background and the fact of this case. The plaintiff, Jacob and Young, was a builder that had contracted with the defendant, George Kent, to construct a country residence for the defendant. A specification in the building contract required that all wrought iron pipe must be well galvanized, lap-welded pipe of the rate known as standard pipe of reading manufacture. The plaintiff installed substantially similar pipe that were not of reading manufacture. When the defendant became aware of the difference, he ordered the plaintiff to remove all of the plumbing and replace it with the reading type. To do so would have required removing finished walls that encased the plumbing, a very expensive and difficult task. The plaintiff explained that the plumbing was of the same quality, same appearance, same value, and even the same cost at reading point. When the defendant refused to pay the plaintiff the money still owed for the work, the plaintiff sued to compel payment. The trial court ruled in favor of the defendant. Then the plaintiff appealed, and the appellate court reserved the trial court decision. The defendant then appealed to the Court of Appeals of New York, the state highest court. In decision and rationale, the Court of Appeal of New York held that the plaintiff had substantially performed the contract and affirmed the state's intermediate appellate court decision. The state's highest court explains that the court never said that one who makes a contract feel the measure of his duty by less than full performance. However, they do say that an admission, both trivial and innocent, will sometimes be atoned for by allowance of the resulting damage, and will not always be the breach of the contract. The question is one of degree. We must weigh the purpose to be served, the desire to be gratified, the excuse for the deviation from the letter, and the cruelty of enforced adherence. As for adjusting the contract price, the measure of the allowance is not the cost of displacement, but the difference in value, the cost complete. The builders were entitled to the amount owed to it, less the difference in value between the specified and substituted point, which the court stated would be nominal. One more thing should be emphasized here that, in general, when a contract provides for a specific amount of money to be paid on completion of specified work, it tends to not deprive the contractor of any payment simply because of a few minor defects or omissions in the work. So the promise to complete the work is more likely to be interpreted as a term rather than a condition precedent that must be met before the contract can even come into existence. If the deficient performance of the term does not render the contract useless, the innocent party must pay the contract price. The innocent party will also claim for compensation for the defect or omission, or will simply deduct them from the contract price. However, if the deficient performance threatens the most important part of the contract, or if the party has only performed half or less of the contract, or the party has completely abandoned the contract, they will not be entitled to any payment for the work. This is because they are not considered to have substantially performed the contract in those circumstances. However, the party might choose to protect themselves against the doctrine of substantial performance by making agreement that one party only had to pay in exchange for the complete and exact performance. How can they do this? They can do this by making entire performance a conceded precedent. It means that a term in the contract should be included to provide for payments to be made in installment as the work proceeds, while withholding the final payment until the work is actually complete. For example, A might enter a building contract with B, who will build a new storehouse for $100,000. It's agreed in the contract that it would take 4 weeks, and A will pay B $15,000 per week for those 4 weeks, and then A will pay B the final remaining $40,000 on the completion. It will benefit both parties. It also benefits B because he has some money upfront to pay for any cost arose to build such a storehouse. But it's also favorable for A to make payment in installment, since it does not leave him $100,000 out of pocket from the beginning of the contract. Furthermore, A is also assured that the builder will not run away with his money or leave the job unfinished.